Hello and welcome to this month's edition of the Legal Eagle Training Podcast. Joining me as ever is Colin Beaumont. Hello, Colin.
Hello, Clive.
How are you?
I'm okay. Apologies for the stubble, but I'm afraid the battery in my shaver has died.
Yeah, well, for those only with their headphones in, Colin, they wouldn't have known. So if you hadn't said anything, there we are.
Fair enough. See, I was just hinting there at a Christmas present from someone watching this podcast.
There we are. Do you think she watches, do you, Colin? Or he, Santa?
Hopefully.
So we thought, quite topically, we'd deal with adjournments, as we're going to adjourn until the new year, aren't we, Colin? So
we are indeed.
We thought before we adjourn for the new year, we'd talk about adjournments. We've fallen into a bit of a rhythm or a pattern, haven't we, in recent podcasts, Colin, of coming up with a dozen things to discuss. And you've very helpfully put together another dozen issues for us to discuss today. Just by way of introduction, and anything you might want to add in a few moments, Colin, I think adjournments are underestimated at times, aren't they? They can be incredibly consequential in terms of, obviously, the case having to continue or the case not continuing. And I'm not sure they get the attention that they deserve, which is often why we talk about these topics, isn't it? Because we think that they're important topics that we perhaps don't talk about enough. And I don't, and I'll be honest, as outstanding and fantastic as my pupil, master and mistresses were, I'm not sure I ever had a situation where they sat me down and talked to me about adjournments and said, look, when it comes to adjournments, these are the points that you should be making, etc., etc. I think we should talk about them and learn about them a bit more in terms of the law and the rules, etc. What about you, Colin?
Yes, I agree. I take the view that you really sometimes have to put in a bit of preparation if you want to be successful in your application for an adjournment, because it seems to me that if you're the advocate in court, it's almost as if from the perspective of the bench, an adjournment is a bit of a negative thing. Well, it's not always a negative thing, say the High Court, and sometimes it's the only really valid course of option. But just because there's going to be an adjournment, when I was an advocate applying for an adjournment, I always used to ask myself the question, yes, but can I give the magistrate something today? Can we make some progress today rather than adjournment, as it were, and this being a bit of a wasted hearing? So always think, what can we deal with today, albeit there has to be an adjournment?
I agree. And to that point, Colin, adjournments are often applications which take you by surprise, aren't they? Sometimes on the day, if you're prosecuting and your witness doesn't turn up, and you might have looked at it and thought, well, this is a case where 9 out of 10 times that the witness is going to be there, and you haven't really had a chance to turn your mind to an adjournment. Equally as the defence, you think, well, there may well be an application to adjourn, but we'll wait and see. It's for the prosecution to make the application, as it were. And you don't really spend as much time as you might considering your response. But I think you're right in the sense that the courts don't like adjournments. Adjournments are dirty words, and the judges and all the court centres have figures and statistics for these things, don't they? How many cases proceeded on the day, etc. And it never looks good for the statistics, does it, Colin? So you have to bear that in mind, don't you, in the background, which isn't really going through prosecution or defence counsel's mind, but it's bad for the statistics, isn't it? And it's always been important, but in today's day and age with the enormous backlog, it's only going to be increasingly important from that perspective, isn't it, Colin?
That's right. I mean, I go back to the good old days when the defence would apply for an adjournment for a fortnight to sort out their legal aid.
Yeah.
Imagine that. We operate in a very different climate these days, don't we? In fact, the name of the case escapes me, but I was reading a case only a couple of days ago in which, because the evidence had been served rather late, there was discussion as to whether or not that evidence should be excluded. And the magistrates decided that they would exclude the entirety of the prosecution case. And the High Court said, there were other things that could have been considered rather than, as it were, the inadmissibility of the entirety of the prosecution case, like, for example, an adjournment in order for the defence to have an opportunity to consider the late evidence.
Yeah, sometimes as the defence, you don't want an adjournment. I remember on a day of trial once in a sexual assault case, the prosecution served DNA evidence of my client's DNA underneath the complainant's bra, which in a sexual assault case where he denied touching her was rather unhelpful. But because they served it on the day of trial, Colin, we managed to get it excluded. Then, of course, we had to adjourn the trial, I think due to lack of court time, for a couple of months, which meant we had time to go and get our own expert. And as you can imagine, our expert was no help. And that evidence went in at the second occasion. So, yes, actually, in that case, we wanted the case to proceed there and then.
In the case I was reading just recently, of course, part of the issue was that neither of the parties wanted an adjournment for reasons I won't bore you with. But the High Court said, look, just because neither party wants the adjournment, if an adjournment is the right thing to do, you must adjourn of your own motion. You don't need an application from the parties to adjourn.
Yeah. I was going to say this point a little bit later, Colin, but as you've raised it, I'll mention it now, because we're going to talk about a case in a little while where both the prosecution and the defence agreed that there should be an adjournment. And I think they probably walked into court thinking, well, we've agreed the adjournment, so the judge is just going to rubber stamp this. And he didn't. Because I think in all of this, we have to be mindful, don't we, that they are adversarial proceedings. But there is always a third factor to be taken into account by the court, which quite often the prosecution and the defence won't. And that's the public interest, isn't it? In terms of the public interest in cases being heard swiftly. And often judges have said, well, you might agree to the adjournment. He said, but I or whoever else has got to be mindful of the fact that there are other cases waiting. And had this case not proceeded today, other cases could have been listed. So no. And then we've seen judges, we'll talk about it in a moment in this case, where they've then done exactly what you said, Colin, where they've then excluded all of the prosecution case under Section 78 and said this would be unfair. Off you go. And that was the end of that. But there we are. Enough of this, the preambles and introductions. Shall we kick off with our first issue, Colin? We're going to talk about adjournment of a trial, aren't we? And you've said, quite rightly, not a decision to be taken lightly.
No, it isn't. I mean, we know from the criminal procedure rules and we know from the criminal practice directions that clearly there is an emphasis upon trials taking place on the day, and the courts will scrutinise or should scrutinise very carefully, say the High Court, any application to adjourn on the day of trial. The more so, of course, if the witnesses in the trial are non-police officers. Clearly, it undermines public faith in the criminal justice system if they turn up to give their evidence and then the lawyers, for one reason or another, decide that they need the case to be adjourned.
I think just as a short aside, when I teach and train, I often ask this question of prosecutors, defence advocates and legal advisors, that when it comes to domestic abuse cases, I wouldn't go as far as to say it's a policy, but I think there is a general feeling among practitioners that the prosecution will always get at least one adjournment. That, as we know, the Divisional Court have said, in cases like Barton, there is a strong public interest in prosecuting these sorts of cases. And as such, I think courts will often, not always, feel that there is a public interest, a strong public interest in ensuring that happens. And if that means there is an adjournment, they will quite often give an adjournment in those circumstances. Can I just mention some law, Colin? You've mentioned the criminal procedurals and practice directions. The law in relation to adjournments comes from the case of Picton, doesn't it? And we know that that's effectively now been codified in the criminal practice directions 5.410. And just very briefly to summarise the criteria to be considered. Firstly, the court's duty is to deal justly with the case, which includes doing justice between the parties. Secondly, the need for expedition. That delay is generally inimical to the interests of justice. It has the potential to bring the criminal justice system into disrepute. That was the point you were making earlier, wasn't it, Colin? Thirdly, that proceedings in the magistrate's court should be simple and speedy. I think that's a point that's well worth making in the magistrate's court. Fourthly, the applications for adjournments must be rigorously scrutinised and the court must have cogent reasons for adjourning. And I said, when it says there must have cogent reasons, I think, I don't know about you, Colin, but when I read these cases where the Divisional Court overturns magistrates' court's decisions to adjourn, often the reason they do that is the absence of cogent reasons. And the sad reality is they may well have good reasons, they just didn't explain themselves very well. Next, the need to review the history of the case, the need to examine the nature of the evidence and whether memories of relevant evidence are liable to fade. I think that's a really interesting point. And you've made the point already, Colin, haven't you, where police officers, for example, are giving evidence and they've got notebooks, for example, they can refresh their memory from. That's a relevant factor, isn't it? The interest of any co-defendants, I think we're going to come to adults and youth a bit later, aren't we? The interest of any witnesses who've attended with particular emphasis on their age and vulnerability. the interest of the defendant in resolving the matter, but also the public interest, ensuring criminal charges are adjudicated upon thoroughly. And then next, the fact the more serious the charge, the greater the public interest in the trial proceeding and the greater the responsibility of the parties have engaged in effective preparation. And I think that's probably the hook on which you'd hang your reasons for allowing an adjournment in a domestic abuse case, wouldn't you, Colin? This is a serious charge, and the public interest, therefore, generally speaking, demands a trial of these issues. Next, where the defendant asks for an adjournment, whether they will be able to present the defence fully without one. And then the last couple of points, the court must consider the consequences of an adjournment in relation to the ability of witnesses and defendants accurately to recall events, the impact on other cases. And that's the point I think often the parties miss, isn't it, when making the application? Because that's not their consideration, in fairness to them. But that's often the point that the court will come back with and say, well, you've made all these points. Well, you also have to be cognizant and mindful of the wider public interest. And then the length of time, and I think in one of the cases we're going to talk about, it's going to be an 8-month adjournment, which the judge wasn't happy about. And then finally, the court must also consider the nature and gravity of fault on the part of the applicant for the adjournment and who is responsible for it. That's a really interesting point, isn't it? So there we are. So as I say, Colin, I find that often with these judgments where they are overturned, because sometimes they're upheld, aren't they? But often it's the failure or absence of detailed reasons. And often even when giving these reasons, there's no mention of the criminal practice directions either, or the case of Picton, for example. And you think, crikey, what help, if any, were the court being given in relation to the law applicable to adjournments? And had they been referred to that, they might have come to a better decision, and one that couldn't have been challenged.
So I think the case of Decani, Decani, is wonderfully illustrative of many of the points that you've just made. It was a classic, really, a classic in that the prosecution attended, obviously, for the trial. Their main or one of their important witnesses, not only did he not attend, but he hadn't been warned to attend. We knew from the PET form why this particular witness was so crucial and why he needed to be there. The defence wanted to cross-examine him apropos the procedure at the police station in relation to the breathalyzer. The magistrates, for reasons best known to themselves, the magistrates decided that they would grant an adjournment for the prosecution. The defence weren't happy. They challenged the matter in the High Court by way of judicial review, and the High Court said this was a classic case in which there should have been no adjournment. There was no good reason put forward by the prosecution as to why this case should be adjourned in order to give them a further opportunity to try the defendant. And the High Court said, what we're going to do in this particular case is we're going to remit this matter back to the magistrate's court with a direction to acquit, so as to put the defendant in the position he would have been in had the judgment been made properly, namely the Crown, as it were, being forced to offer no evidence and the matter be dismissed. Crikey, when the High Court says we're going to remit this matter back to the magistrate's court with the direction that they acquit, you know that something really has happened at the magistrate's court stage.
One other short point to add on the law, of course, we're talking about adjournments generally here and broadly. The criminal practice directions go on to talk about adjournments in where the defendant is absent. Again, it's something I don't know if it is mentioned and not recorded, but you very rarely see mentioned, do you, Colin, of Section 11 of the Magistrates' Court Act 1980, which of course says that there is a presumption that the trial, if the defendant is 18 or over, there is a presumption that the trial will proceed in his or her absence. So as the defence, if you're applying for an adjournment because your client's not there, put it this way, you're already on the back foot, aren't you? Although I say you're on the back foot, some people might suggest, Colin, that your client not being there is actually a bonus. And I could certainly think of a couple of cases where my client not being there was hugely helpful, Colin.
The point is to be made that I think it's the Magistrates' Courts Act 1980, Section 11. You mentioned Section 11. I think it's 2A, one of the subsections, 2A, to the effect that if you are for the defence, of course, you have to show a good reason, good cause as to why the trial ought not to take place today, your client being absent. And I would have thought an absolute classic is that you're in possession of some sort of medical certificate or medical report to the effect that he is unfit to attend this trial today. And the High Court have said, and goodness me, they've said it numerous times, you shouldn't be going behind a valid report or a valid medical certificate saying unfit to attend this trial. I could throw the case of Killick at you, Killick. I could throw the case of Drinkwater at you. These are important High Court cases in which the court said the magistrates were too hasty to decide that the trial should proceed when the defence were in possession of a perfectly valid medical certificate indicating their client was just unfit to attend for the trial. Not to be confused, of course, with those medical certificates that say unfit for work. Yeah.
Going to court isn't work, is it, Colin?
Unfit for work. I remember once I was attending court and the partner of my client, who wasn't there, gave me a scraggy little piece of paper that said that he couldn't attend because he got the flu. The problem was that flu was spelled F-L-E-W. So I quickly gave that back to her and explained that flu was an abbreviation of influenza.
Yeah.
And we wouldn't pervert the course of justice today, would we?
No. And that all comes, doesn't it, Colin, from the case of Jones, doesn't it? R.V. Jones, the old House of Lords, back in about 2000 now, wasn't it, when we first started trying cases in defendant's absence, really, didn't we? And we got that guidance. Was it contrary to Article 6? The answer was no. And indeed, as a result of that, we then had boxes put on forms, didn't we, on what was then the PCMH form, now the PTPH form and the PET form, etc., saying, have you warned your client about two things? One, if they plead guilty, they'll receive credit for that plea. Two, if they fail to attend their trial, then the trial may proceed in their absence. So, that's one of the safeguards, isn't it? The built-in safeguards. If you don't turn up, you need to be warned about that this may proceed in your absence. And yes, it's something that we all just do now as a matter of routine, don't we, if we were attending court still, you and I?
And I make the point that clients don't attend for their trial for all sorts of reasons, not least the fact that they're actually slightly concerned about going into the witness box and what they're going to say when they testify. And of course, if they are convicted in absence, they can say for forever and a day, can't they, to their family and friends, well, what can I say? Convicted in absence. Never got the chance to put my side. We must never underestimate the psychology behind clients who don't appear.
I agree. And we see, I was listening to a podcast this week, Colin. Obviously, there have been huge reforms and suggestions of reviewing the way we try people, whether they have jury trials or not. And I heard one very responsible commentator on one podcast this week talking about the defence advocate gaming the system, saying, well, if he knows that his client's trial is not going to come on for 3 years, I thought, hang on. Why are you confusing counsel with their client? As you say, Colin, you can tell them that it would be in your best interest to turn up, but it's advice, isn't it? I mean, same way your doctor tells you should go on a diet or give up smoking or drink a bit less. You take or leave that advice, don't you? And so I was a bit frustrated to hear this journalist conflating advocates with their clients. But yes, as you say, the psychology is interesting, isn't it? And which is always one of the main reasons why, as an advocate, I was very loath and reluctant to advise a client not to give evidence, because, of course, if they didn't give evidence and they were convicted, ground of appeal number 1 would be, my barrister told me not to give evidence. Had I given evidence, I could have answered all their questions and resolved all these issues. So there we are. Good. Well, we've skipped on to point 4, Colin, without dealing with points 2 and 3. So let's rewind, shall we? Point 2, and that's to develop the point you made earlier, really. The case has to be adjourned, but can we not make some progress today? Things like disclosure, witness summonses, those sorts of things. And that's what you were suggesting, isn't it, Colin? If you are going to make an application, then sometimes if you can, while of course you're taking away a hearing from them today, can we make a little bit of progress today?
Can we not agree some of the evidence we were a bit iffy about last time? It'll do you no harm if you're applying for an adjournment to give the court. You're just giving the court something, aren't you? Well, look, today's hearing has actually been rather useful for these reasons.
Not completely wasted. And again, the psychology of it, Colin, is important, isn't it? When we do these things, again, something we don't talk about enough.
I think lawyers underestimate the prep required to get the adjournment that you seek.
Point number 3, Colin. First listing of the case, not guilty plea has been entered today. An adjournment will clearly be necessary. But should the court really be embarking upon such issues as bad character and hearsay today on the first listing? What's your view, Colin?
You see, I hear on the grapevine that district judges are rather fond of saying, well, look, let's deal with the hearsay today, shall we? Let's deal with the bad character issues today, which is okay if those matters are easily resolvable today. I'll give you an example. It may be that we're going to adjourn the matter. It's a trial. It's theft by way of shoplifting. And the client has various thefts by way of shoplifting already on his or her record. Well, I think that's probably something we can agree today. It might be we agree that those convictions should go in anyway to take the steam out of the Crown's application. Or if we're not, the chances are the court is going to say, well, yeah, these are clearly admissible. They show a propensity to commit the very act, which will be the substance of the trial, the case that we're about to adjourn. So there are relatively simple and clear-cut cases, but there are other cases that are not so simple and clear-cut. And in those circumstances, my view as the advocate would be, well, with respect, the notices under the criminal procedure rules are there for a reason. They are there in order, as it were, that both parties can formulate the best arguments to put before the court as to why this character or hearsay evidence should go in or should not go in. So with respect, I think it's one of those cases whereby the notice periods should be complied with. We need time to consider these matters carefully. They are not matters that should be dealt with today.
I agree, Colin. And what I'd say, going back to your example, it's exactly that example I give when teaching, that sometimes I suggest to defence advocates, you might want to agree it at the first hearing, because if you don't, the Crown might go and do some homework. Now, don't get me wrong, the fact that your client's charged with shoplifting and he's got 5 previous shopliftings from shops is unhelpful. But I tell you what, if you don't agree it on the day and they go and do a bit more homework and it turns out that not only has your client got previous for shoplifting, but he's got previous for shoplifting bottles of red wine from supermarkets, and he's alleged to have stolen a bottle of red wine from a supermarket, that's even more unhelpful. And it might, just might, I'm not promising it will, it might be that you could just see off that detail being adduced by the Crown. I mean, not to say that, of course, if your client gets in the box, that he's probably going to have to give a little bit of evidence about what these previous are, or the prosecution might ask him, and he might have to then confess and say, well, it was a bottle of red wine. I've got a bit of a penchant for Chateauneuf de Pape, and that's what I tend to steal every time I go in. But yes, sometimes less is more, isn't it, Colin? And you can avoid these little details which can be even more damaging. It's not to say the application's not already been damaging, but you can avoid sometimes these little details coming out in the future, can't you? So there's something to think about, isn't it?
I was talking to a defence lawyer the other day who left court feeling that she'd been, I think bullied is too strong a word, but she felt under pressure to agree hearsay on the very first day. The issue ought not to have been forced on that first day, the not guilty plea having been entered. And we know, don't we? We've got that case of Virginia and Smith in the year 2000, in which the Court of Appeal said, did they not, the criminal procedure rules are not decorative. They are there for a purpose, and the notices are there for a purpose, because the district judge had said to this particular lawyer, well, notice periods, I can dispense with all of those, can't I, under the criminal procedure rules? And she didn't know quite what to say. Well, of course, what she should have said was, well, yes, you do have the option to dispense with notice periods. With respect, that's not to cover today's scenario of where you want to force these things through today, it being the first listing and my client just having entered a not guilty plea.
The case of Smith was a bit later than 2000, Colin, because the criminal procedurals didn't exist then. So it was it 2020?
Could be.
It was an Ipswich Crown. It's an Ipswich Crown Court case, wasn't it? It was Lord Justice Irwin. Yeah, and I love that line. The criminal procedurals are not decorative. And this was a serious, non-recent allegation of sexual offending, wasn't it, against a neighbour, I think, or a family, and then he was supposed to have made a confession, wasn't he?
Yeah.
And all these sorts of things, yeah. And as you say, the defence lawyer just tended to nod through a lot of it, and he was represented by different counsel in the Court of Appeal, and you can draw such inferences as appear appropriate in those circumstances. So, but yes, there's a great line that. The criminal procedurals are not decorative.
I'll agree. I concede the point. It was 2020. The criminal procedurals are not decorative. Do you remember which paragraph of the judgment they said that in?
Of course I don't.
Oh, it's
You probably do.
Paragraph 50.
There you go. There we go.
You're a light. Can I say you're a lightweight, Clive? You're a lightweight.
I know. It's even called Smith. I should know, shouldn't I? I should know.
Absolutely. Any relative?
Yeah. Well, there is another legal commentator who always says that about sex offenders. He says, they're always called Smith, aren't they? So thanks for that. Yeah, great. Moving swiftly onwards.
The last time I was that precise in something, from a question raised from the floor by one of the attendees at a conference, I gave the answer, and someone at the back actually Googled it. And then shouted out, "He's right!"
They fact-checked you, did they, Colin?
They checked it. They Googled it once they were there.
Well, because the point is, you could have said any number and they wouldn't have known any different, would they?
So, indeed. Absolutely. It was a citation. It was a citation of a case. It was a case of, would you believe it was another Smith case? Another Smith case, 1984, 2 criminal appeal reports at page 978. Carry on. Is it a blessing or a curse? I think it's probably a curse.
Yeah, you should get out more.
I'm on medication for it, Clive, if it helps.
Apparently not. Well, we've dealt with medical certificates, so you'll never need a medical certificate for not attending our podcast, will you, Colin? So we can skip on to point number 5. The adjournment, and we've touched upon this a little bit already, but the case is absolutely unavoidable, this adjournment. Has the defendant or one of the parties in the case been guilty of, quote, an unreasonable or unnecessary or negligent act or omission whereby the adjournment was required and costs had been incurred by the other party? And of course, this raises, doesn't it, Colin, the spectre of wasted costs under sections 19 and 19A of the Prosecution of Offences Act 1985. Same piece of legislation, of course, that set up the Crown Prosecution Service, didn't it? So.
And it might be, obviously, if your client is paying you privately, of course, you're always under a duty to protect your client in costs. And if your client is paying you privately, and if you do turn up, and if the Crown do have to apply for an adjournment, and it's their fault, you might make the application with extreme reluctance, but you're under a duty to protect your client in costs. And if the test is met, you might somewhat reluctantly have to quantify today's hearing costs and apply for those costs to be met by the Crown. You have no choice in the matter, really, if your client's paying you privately. The test, of course, is that the party who's been guilty of an unreasonable or improper or negligent act or omission whereby the other party has incurred costs. And I can't think of a better example, than not warning your witnesses to attend your trial. You might say, well, it was the police, but you can't hide behind the police on a wasted costs app.
Yeah, prosecution is indivisible to that extent, isn't it, Colin?
Indeed.
Yeah, I don't think, I never had an application made against me personally, but I did see it on occasion.
It's sometimes overlooked, of course, that the application can lie against the defendant. And the classic might be the defendant who doesn't attend the interviews, so the Crown Court judge has no reports available today. Well, the case has to be adjourned, wasted costs against the defendant. And who knows, the judge might put the defendant in custody in order to get the reports.
Yeah, the judge usually punishes them in other ways, doesn't it? It never helps, does it, if you're trying to apply for a non-custodial sentence for you to then not turn up to your probation interview. So, never the best start. Good. Okay, point number 6, halfway, Colin. Neither party wants to apply for an adjournment. Does the court need a party to apply before it can adjourn, or can a court always adjourn of its own motion? And secondly, to all of that, equally, the defence and the Crown both agree an adjournment is necessary. Will the court concur?
Let's take the first point first, and it sort of harkens back to that case that I was reading a few days ago, because the facts were interesting in the sense of the statement had been served late upon the defence, albeit the Crown had had this statement for some time. And the Crown said, OK, we concede the point. We don't want an adjournment today. We'll just agree that we won't use that statement in the trial. And the defense said, well, no, it's a bit more nuanced than that. Because, of course, had we had this statement, obviously, we would have shown it to our expert who's not here today. We would have shown it to our expert. And who knows, our expert may have said something, as it were, that was applicable to the case, to the benefit of our client. So, in other words, we can't avoid the mischief that the late service has caused simply by you saying you won't rely upon that statement. And the Crown said, well, we're not applying for an adjournment. And the defence said, well, we're most certainly not applying for an adjournment. It's not our fault that this statement has been served late upon us, whereby we have not got our expert's opinion on it. And so I think that caused a problem for the magistrates that neither party was applying for an adjournment. And they wanted the matter resolved today. And the matter was resolved very unsatisfactorily by the magistrates that were deciding that because of the late service of that statement, all of the prosecution evidence should be deemed inadmissible. And the High Court said, ooh, hey, sledgehammer to crack a nut there. The court can always adjourn. It doesn't need, as it were, an application from the parties. And the court should have considered the far lesser option of a series of bad options, namely the option to adjourn.
It's a cunning tactic at times, isn't it, Colin? When because I always mention this point when it comes to domestic abuse cases, the complainant's not there, and obviously the Crown want an adjournment. But there are certain situations where I think people always assume, well, you should apply to adjourn, and it might be your client's not there. You've got no good reason why he's not there, and it might be that the complainant isn't there either. Okay, so the prosecution might turn to you and say, well, looks like we're agreeing that the case should be adjourned then, doesn't it? And you might say to him, no, while my client isn't here, it's for you to prove the case and you don't have any evidence at the moment. So actually, your application to adjourn, not mine. I think sometimes we too often default to we should be applying for an adjournment then, when actually you can make life difficult for your opponent, and seemingly in this court by saying, well, I'm not applying for an adjournment. So that's that one's on you, I'm afraid.
Who's to say I would ever call my client anyway? My client might go to the dock, give you his name and address, and that's it.
Or he might have already said to me, she's not going to turn up. And yes, I did hit her. So I was never going to call him in a month of Sundays anyway. So, and here we are. He was right to that effect.
Indeed, which is why I wrote on your wretched pet form, the prosecution have put to the proof of its case, because we had no defence, Malcolm.
The wretched pet form. I've never heard you use that phrase before, Colin. I didn't know you were so fond of it, Colin.
The wretched pet form.
This podcast is recorded on behalf of Legal Eagle Training. You can find us at legal-eagle-training.com.
Legal Eagle Training has nearly 100 one-hour recordings already on the website, and most of which come complete with notes. We've been doing these now since June 2020 on topics as diverse as
the Magistrates Court, including the Youth Court,
life at the police station,
road traffic,
advocacy, Magistrates Court advocacy, Crown Court advocacy,
criminal law updates, including case law and the latest legislation,
and the subject we both know most dear to your hearts, the billing of criminal legal aid.
The website is constantly being updated with new courses on the latest topics. We add 2 further presentations on the website per month. Each presentation lasts an hour and comes with a full set of notes. Do visit the website, as there's going to be something there that appeals to you as someone involved in criminal law.
Right, back to the episode.
As you know, Colin, this is one of my favourite cases. A case of Boardman from 2015. This was Sir Brian Leveson. He's been in the news a bit this week, hasn't he? And just more broadly for various things. And this was a classic, wasn't it? It was at Chester Crown Court, and the defendant very briefly was charged with, I think it was a malicious communication act offences, making some nasty phone calls to several women. And the evidence against him, it was a circumstantial case whereby he bought the mobile phone top-up cards for the phones, and the Crown said, by way of inference, you can infer that he bought the cards and therefore it must have been him who made the phone calls. And his defence was very simple. Not me. I did buy the phone cards, but I didn't make the phone calls. Now, funnily enough, as a result of that, then the defence were very interested in the cell site evidence. So they could show, for example, if the Crown had evidence that one of the phone calls had been made from Manchester and he had a convincing alibi because he was in Newcastle or Cornwall at the other end of the country that day, then that would have tended to suggest it wasn't him who made the telephone call. So we get to the day of trial, don't we, Colin? The Crown accept that they've not disclosed the unused material which the defence expert needed to examine for his report. And he needed at least 4 weeks to do that. The prosecution said, well, we agree an adjournment is necessary. So both parties went in front of the judge and said, can we have an adjournment, please? And the judge said, no. He said, the next trial date is going to be in 8 months. He said, we can't wait that long. And therefore, I'm excluding all of the prosecution's phone evidence, which left them with no case. And they therefore had to offer no evidence, although, of course, they didn't offer no evidence to the extent that they appealed under Section 58 of the Criminal Justice Act 2003, which is where the prosecution have a right, as we know, isn't it, to appeal a terminatory ruling. And it went before the Court of Appeal. I was about to say Divisional Court because Sir Brian Levison was the president of the Queen's Bench Division it then was, but he was sitting in the Court of Appeal. Very handy. He was able to refer to his own review on the efficiency in criminal proceedings. And he said no. He said the judge, I think it was Judge Dutton, and Chester Crown Court were entitled to the support of this court, and we uphold his decision. And you might think, well, that's the end of that then. What's that got to do with me in Plymouth Magistrates Court or Durham Magistrates Court tomorrow? Because this is a kind of case, sadly, that'll come before the Crown Courts most weeks. And Sir Brian had what I always refer to, Colin, as his Columbo moment, for those old enough to remember Columbo. His, just one last thing, just one final thought before we leave this case. He said this. He said, in the future, he said, the court would be perfectly entitled to refuse an application to adjourn by the defence. Why? Because they didn't raise it sooner. So in a case like Boardman, where you need 4 weeks for your expert to look at this material, you should probably be bringing the case back to court about 5 or 6 weeks before the trial date. As the Court of Appeal described it, and I think that the Crown Court judge described it, the position, he said he'd been put in an invidious position. And the Court of Appeal agreed, said, look, you can't come to court and effectively paint the judge into a corner and say, look, the only option you've got now today is to adjourn. You've not got an opportunity to make orders for disclosure, for example. There's nothing else you can do. Why? Because we didn't bring this back sooner. So I think when it comes to adjournments, particularly applications to adjourn on the day of trial, when it comes to issues like disclosure, I think this is such an important case for defence advocates, for prosecution advocates, and indeed legal advisors and the judiciary as well, to be mindful of. That if you wait, that it's not just the fact you've made an application to adjourn. The question is when you make that application to adjourn. And so I think if you don't understand Bournemouth, then I don't think you understand that the culture of the criminal courts has changed significantly in the last 15 to 20 years as a result of the criminal procedure rules.
I agree, and I've nothing further to add.
I like Boardman. I just think it's a really important case. And paragraph 43, Colin, in relation to Sir Brian's comments, there we are. Touche.
You can say 15 all.
Right.
15 all.
Point 7 then, Colin. Consideration of whether or not the court should adjourn and go part heard on the day. Ooh, now there's a swear word in court, part heard.
Yeah, never an application to be made lightly.
No.
I remember a case once in which my witness had to leave. She had to leave. She'd been there all day. She had to leave to go and pick up her children from school. And so I asked if her evidence could be out of turn before the client's evidence, because then she could go and pick up her children. That was refused. And so we then had the client give evidence, and I then made an application to adjourn par heard in order that we hear the defence witness next time who couldn't attend. And I thought it was a valid application, really, to adjourn at that stage par heard. The justices were not mindful to it. It's very difficult to get a trial adjourned par heard. They were not minded to agree, and so Custer's last stand, as it were. I applied, which caught the prosecutor off foot a little, for the statement to be read as a hearsay statement. Section 1141D of the Criminal Justice Act 2003. And the prosecutor said, well, I'm not sure I want the statement read. Obviously, if this is a witness we'd like to cross-examine. And I said, yes, we'd all like her to be, we'd all like her to be here, wouldn't we, Malcolm? But we know why she's had to go. And I said to the magistrates, might I respectfully remind you of the definition of a fair trial? A trial can be said to be fair, of course, when an impartial observer in the public gallery, having nothing to do with the case, and that's why they're impartial, would consider that the defendant had been afforded a fair trial. I said, would you consider that the impartial observer might take the view that my client hadn't been afforded a fair trial if you refuse yourself the opportunity to read this statement? The weight and the quality you give to the statement is a matter for you. And the magistrate said, yes, you argue the point very eloquently, Mr. Bow. Application refused. So there you are. But that was just me trying to get the magistrate to adjourn part heard once the client had given evidence. And sometimes that's a useful tactic because although they may not be in agreement to going part heard at the close of the prosecution case at 1 o'clock, they might be more amenable to it later on, perhaps at 4 o'clock. Every case on its own facts.
Quite. And I have to say, particularly in the magistrates court, that the Crown Court's different, isn't it, in the sense that the case goes part heard every day. You go from adjourn on Monday to Tuesday and so on. And if the case rolls over another day or two, it's not an issue. In the magistrates court, it is, isn't it? Because you have a half day or 1 day listing and everyone turns up on that day. And the next day, it's a case of, well, all bets are off because, quite frankly, everybody could be in a different courthouse, couldn't they? Different court building the next day, from the legal advisor to all the different magistrates and the prosecution and defence advocate. Often this comes down, and you'll know this better than I can, I haven't been a legal advisor for some time, but it comes down to practicalities. And I remember doing, I think I had 2 or 3 cases in the magistrates court that went part heard. And one of them, sadly, we had to go down from a bench of 3 to a bench of 2. One of the magistrates, I think he'd only recently retired, and him and his good lady had booked various cruises. So every time, it was like a game of diary battleships, Colin. Every time a date came forward, no, he's on a cruise. No, can't do that one either. No, can't do that one either. So sadly, of course, because he'd been there and heard the whole day of evidence, we had to go off to another date without him. But if you indulge me just for a second, Colin, my most bizarre experience of going part heard was in front of a very experienced district judge, and I won't name him because it's not fair. We adjourned the case. My client was a youth, and the complainant was a young girl who he'd allegedly been harassing. And we had a full day of evidence, and I thought I cross-examined her quite skillfully because it was a challenging case. We came back 6 weeks later, and the legal advisor came out to find me. He said, we've got a problem. I said, what's wrong? I said, the district judge, no, he's here. He said, but he can't remember anything about the case. I said, what do you mean he can't remember anything about the case? He said, judge has asked you all to come into court. And we went into court, and the district judge said, I know we've gone part heard in this. He said, but I'm afraid I can't remember any of this case. He said, I've reread my notes. He said, and I've even asked the legal advisor if I can rewrite her notes as well. And he said, I have no independent recollection of this case whatsoever. And none of us knew what to say. Our jaws hit the ground. Of all the things we expected to happen that day, that was the last one. Anyway, I'll cut the story short. He ended up with a bind over Colin. The complainant had moved away, many, many miles away. I gave her a call, said, I don't want to come back and give evidence. The Crown said, well, will he take a bind over? I said, of course he will. Of course he will. So,
Excellent.
Absolutely bizarre. Yes. So there we are. There's a reason not to go, well, and if you're defending, there's a good reason to go part heard. Because we talk about memories fading, and this is what we mean. The district judge couldn't remember a thing about the case. I don't know what he'd been up to in between.
My funny recollection apropos part heard is turning up at Ealing Magistrates Court one day, and the legal advisor, a really clever chap, and a lovely Oxford man, lovely bloke. He was in a right his was. And you could see that something was wrong. And I said, whatever's the matter? He said, well, I don't understand any of the notes. He said, I don't understand any of the notes from last time. I said, oh, gosh, who wrote the notes? He said, well, I did, you idiot.
There we are. The dangers of going to sleep, eh?
The dangers of going part heard. Legion.
Yes, exactly. And so for that reason, it is always a difficult application to make, isn't it, Colin? Always a difficult application to make, particularly in the magistrates' court. So there are. Good luck. You are pushing water up a very steep hill, aren't you, in such circumstances, is what I'd say to everyone. There we are. That's point 7, Colin. Colin, number 8, you've put motoring, the real reason the defence need an adjournment today. What is the real reason? Tell all.
Well, the real reason may be this. The law says that you can't argue the same exceptional hardship to avoid a disqualification as a totter. You can't argue anything that you've successfully argued within 3 years of the conviction. Oh, within 3 years of the conviction. Very interesting. So we're not going to plead guilty today, are we? Why? Well, if we did, we'd be convicted and therefore precluded from arguing the point we want to argue. So that today's application is for adjournment. We have no defence, you understand. It's just that we can't plead guilty today. We have to get out of that 3-year period. So what do? Well, we put on the PET form, we put the prosecution to the proof of its case, and we apply for an adjournment today. This trial will never go ahead as a trial. We'll crack the trial, obviously. Quite happy to have a listing earlier than the trial date in due course, so long as it takes us outside the 3-year period. And that's why the defence are applying for that adjournment today, because they want to put an argument they cannot in law put before the court today.
Colin, let me ask you this. As the magistrates' court is not a court of record, how do we know what arguments they put forward previously?
Oh, the Court of Appeal have said if there's any suggestion that your client, as it were, had a lower disqualification than the law would have permitted last time, it is incumbent upon you to seek the court record of the previous hearing to find what was noted on the record apropos the arguments that the chairman announced that were successful in making that disqualification less than the period that would otherwise have been given. That is your job, say the Court of Appeal, and more often than not, you'll need an extract. We used to call it an extract in my day of the court record from the previous hearing.
Yeah, very good. That was a genuine question. And I suppose the other potential reason you might know is because you might have been the same advocate 3 years previously. I used to come across an advocate from another chambers when I was a pupil. She had a client. He liked to drive quite fast and usually on the M4 or the M40. She developed a little niche practice down the M4 corridor at various magistrates' courts trying to keep him his licence, and she managed to achieve that on several occasions. So he became rather fond of her, and she was his counsel of choice every time he got done for speeding and was going to be disqualified. So yes, I suppose there's every chance that you as the advocate might know those reasons as well. And of course, professionally, you would be bound not to put forward those arguments again, wouldn't you? So,
of course, just going back to something you said earlier, it's not my application for an adjournment today. It's my client exercising the option to apply to the court today for an adjournment of his case. It's not my application for an adjournment. His application for an adjournment. He's instructed me to apply for an adjournment on the basis he wants to argue something he can't argue today.
Of course, you can't tell them that, can you?
I can't fault him on that.
No, absolutely. There we are. Well, that's uncovered that mystery, the real reason in motoring cases why you might want that adjournment. Good. So point 9, Colin, a not guilty plea has been entered on the first day of first appearance, but does the case really need to be adjourned? So it's one of those cases where the prosecution's facts are accepted, but the defence maintain the facts do not meet the test as regards the commission of the offence. So it's purely a legal argument and all of the prosecution evidence is agreed. Are we definitely adjourning then, Colin?
No, I don't think we are. Not if we've got a district judge. I would say, look, the long and the short of it is this. We've been charged with dangerous driving. We accept that we were driving, but we say driving in that particular manner, does not meet the test for dangerous driving. Probably meets the test for careless, but not dangerous. All of the prosecution evidence can be agreed. They can summarise their statements now. I won't call my client because it's not a factual dispute. I will simply be addressing you to apply your mind to the legal test, to the facts that have just been put before you as agreed. There's absolutely no need for this case to be adjourned. District Judge said, I couldn't agree more. I'll list it at 2:00. I'll read the papers over lunch.
And do you have that happen when you were?
Oh, yeah.
Yeah, client wants this dealt with. And particularly in the current climate, if they can say, right, I can dispose of another case today, then yes, as you say, if it's a district judge or a deputy who feels confident in doing that, and they'll say, see you at 2:00. We'll back through this.
Absolutely. And yet, if all you're doing is applying a legal test to a set of facts on agreed evidence following a not guilty plea, you don't need the matter adjourned for trial.
No. Effectively, you're just asking for a ruling on a point of law, aren't you?
Of course you are.
So, yeah.
The judge said, I'll read the papers over lunch.
Yeah.
Didn't even want to
Very
hear
good.
from the prosecutor when we came back. Will you address me? I've read the papers.
Very good. And how did that end? Well,
Oh, no. Badly. But in a sense, it did end well. We got a lot of favour by the way we had approached the matter.
yeah. Not to be underestimated, I dare say you were, generously dealt with when it came to sentence. Here we are. Good. Point 10 then, Colin. In consideration of whether or not the case needs to be adjourned in order for there to be a Newton hearing, would it be lawful for the court to refuse to adjourn for a Newton hearing and then to sentence on the prosecution facts today, albeit those facts are obviously not agreed by the defence?
Most of the time, if it would materially affect the sentence, of course, it would require an adjournment in order for the case to go to a Newton hearing. The Crown bearing the burden, of course, in a Newton hearing to establish their facts to the required criminal standard. The case of Navarro and the City of London Magistrates Court. But I've had more than one instance where a district judge has said to me, yes, I hear what you say, Mr. Beaumont, but I don't think a tribunal would ever find your facts. I think your facts are fanciful. Yeah? No set of facts that a reasonable tribunal would ever find. And on that basis, I'm not going to adjourn for a Newton hearing. I'm going to sentence today on the Crown's facts. Do what you will. So in other words, the district judge knew that there is case law to the effect that if the defence put forward a version which the court considers to be wholly fanciful, no set of facts that any reasonable tribunal would ever come to, they're entitled to disregard the defence facts and sentence on the Crown's facts today. But it would be rare.
I've had that before as well, where a client, I was a firearms case, actually, a client gave me, I didn't think it would pass muster in exactly that way, Colin. And so when in mitigation, I put this forward and I'd already said to my client, I said, look, if those are your instructions, I'll tell the judge, but he may well ask for a Newton hearing. And that would mean you getting in the box and giving evidence. I said, if he asks for that, are you willing to give evidence? And she said, no, I'm not. And so I went upstairs and I mitigated, and exactly what I said was going to happen happened. The judge said, well, that's fine, Mr. Smith, you want to say that? He said, would your client like to come forward to the witness box and give evidence on oath to that effect? I said, no, thank you, Your Honour. Because you're losing credit as well, don't you, Colin? I mean, you've got to say to him, you can put this forward if you want, but if you lose, you've pleaded. Come on, get the benefit of your credit. You're almost, shooting yourself in the foot here, aren't you? I mean, my client might literally have shot himself in the foot. But yes is the short answer to the question, but it would be only in a very limited number of cases, wouldn't it, in which the court, as you say, is entitled to reject the need for a Newton hearing without hearing evidence, where the defence case is simply preposterous, quite frankly. Okay. Point 11, nearly there, Colin. The case is to be adjourned. Should it simply stand adjourned, or should a defendant always be subject to unconditional bail?
Different legal advisors seem to take different views on this. The position being, of course, that many prosecutions these days start by means of a written charge and a requisition. And if the client attends on the requisition together with a lawyer, it's difficult to imagine a client, as it were, who's being less cooperative with the criminal justice system. He's here today. We've attended. He's instructed a lawyer. With respect, what more do you want? Why do you feel the need to put him on bail? Why can't the case simply stand adjourned? Obviously, if he doesn't attend on the next occasion, no doubt you'll tell him now he runs the risk of the trial proceeding in his absence. But why do we have to go from a requisition to unconditional bail?
And what would happen, Colin, if he didn't turn up on the next occasion in terms of getting him back before the court in the future?
Well, what would happen is that the magistrates, as it were, if they convicted, they could then take the view, we have convicted you in your absence, we are unwilling to sentence you in your absence. We can either send you an adjournment notice saying come next time for sentence, or we could issue a warrant. On the basis that we are unwilling to sentence you in absence, you now stand convicted. The kinder option would be to send the adjournment notice saying, look, we've convicted you in your absence now. We're unwilling to sentence you in your absence. This is your opportunity to attend for the sentence. And woe betide you if you don't. You might find you have to come before us on a warrant. Assuming the boxes are ticked, the offence is potentially imprisonable, he's 18 or over, blah, blah, blah.
I think Section 11, Colin, says they can't send you to prison in your absence, where that's the way that the proceedings have been instigated. They can't send you to prison in your absence.
I'd agree with that. It's one of the sentences they can't impose on your absence if the matter proceeded by way of requisition, and that's reinforced in the criminal procedure rules.
Finally, then, Colin, severance of youths from adults and adjournments to the youth court for the trial to take place there. Tell us a little bit about that, Colin.
Well, just because he's elected as an adult to go to the Crown Court, just because the justice is about to decline jurisdiction and he's going to the Crown Court, does the youth necessarily have to follow the adult? Well, we've got the allocation and sending guidelines, haven't we, published by the Sentencing Council, March 2016. We've also got that document published by the Justices Clerk Society, in which they do say, don't they, the justices should consider very carefully whether or not to sever the youth from the adult at that stage and remit to the youth court for sentencing, or rather for trial, even remit for trial. Now, the witnesses, as it were, may be inconvenienced by having to give their evidence twice. That is unfortunate, but it's not the sole test, is it? That is merely a factor of a number of factors for the court to consider in deciding whether, in the interests of justice, the youth should be severed and remitted to the youth court for trial. There's a whole list of factors for consideration. And all I'm saying is I just wouldn't want it to go through on the nod. They don't have to both be sent. There can be severance, there can be an adjournment to the youth court for trial.
And can I say, Colin, certainly from when I first started, I don't know about you, but I feel like there's been somewhat of a culture change in the courts in relation to that, because as you say, the court has to bear in mind the interests of justice, and what seems to be the overwhelming interests of justice were twofold, in the sense, one, it was the fact that witnesses should not have to give evidence twice. Two, we were always trying to avoid inconsistent verdicts. So, for example, the adult could be tried in the Crown Court and convicted, and the youth tried in the youth court and acquitted, or vice versa. And those two priorities seemed to trump everything else. But it very much feels like the swift determination of a case for a young defendant, for a youth, now is the overwhelming priority in these cases. So from when I started, I feel like there's been a culture change and a shift in mindset from the courts. I don't know about you.
The more so, Clive, and the more so with the waiting times at the Crown Court at the moment. A relevant factor would be how quickly can this youth be tried?
He could be an adult by the time it's tried.
In fact, the defence might not want to apply for severance at all for that very reason.
Well, quite. And actually, for the adult, it might benefit them, because when they get to the Crown Court might list it sooner than if it were an adult on their own, because there is a youth connected to it. So, swings and roundabouts.
Absolutely. There's a lot of thinking to do, isn't there, as to tactically, how best to proceed.
Good. Colin, that's bang on an hour. I don't know how we do it, but there we are.
You do it with mirrors, Clive.
Smoke and mirrors. So there we are. Food for thought. I hope we've given people some useful help, guidance, suggestions in all of this. And as we are adjourning for Christmas, and it is now December, so I feel like I can use the C word. A Merry Christmas to you all.
Indeed. Merry Christmas, Happy New Year. And of course, the good news for criminal legal aid lawyers, a statutory instrument just been published, hasn't it? Increasing your fees with effect from the 22nd of this month, 22nd of December.
And another 34 million in the Crown Courts, Colin.
Nice little Christmas present. Yeah. Only in relation to your lower crime work, though, those increases 22nd of December. They're going to increase the Crown Court fees as well, but we've yet to get the statutory instrument published for that. I'm talking essentially police station work. I'm talking magistrates' court work, adult court, youth court work. Say goodbye, Clive.
Goodbye, Clive.
Bye. Well, thank you for tuning into this particular edition of the Legal Eagle podcast. We do hope that you've enjoyed it. You can find further episodes on our website, legal-eagle-training.com. On behalf of myself and Clive, thank you. Say goodbye, Clive.
Goodbye, Clive.